The never-ending war, Ripple versus SEC. Ripple's remarkable dogfight with the Securities and Exchange Commission has taken a dramatic twist after US regulatory authority suffered a setback in its pursuit of the blockchain-based digital payment company. Earlier this year, the defense case for the San Francisco firm had looked dead in the water, but the tide may now be turning in Ripple's favor, according to legal observers. The SEC filed its lawsuit a few days before Christmas 2020, claiming its founders had illegally marketed its native XRP token to retail customers, allowing the firm to raise business capital through its sales as an unregistered securities offering. Join us as we go through the latest development in the lawsuit. In today's episode, we will show you the never-ending war between Ripple and Securities and Exchange Commission. So, stay tuned with us till the end.
Hey guys, welcome back to our channel, The Crypto King. Here you will get the latest cryptocurrency news, all investing information in crypto, and how to earn money from crypto. If you are new here, please like and subscribe to get everything you need to know about cryptocurrencies. Don't forget to click the bell icons so you get notified every time we upload a new video. So, let's get started.
The latest turn of events. The never-ending legal saga between SEC and Ripple has had a new development. Ripple Labs has filed a motion to compel the Securities and Exchange Commissions to turn over internal documents regarding cryptocurrencies, Bitcoin, Ethereum, and Ripple's XRP. The motion to compel the financial watchdog to hand over the documents follows a back and forth between the two parties and Judge Netburn. The SEC has been refusing to produce the records despite Judge Netburn's insistence. She has told the plaintiff to turn over the documents twice already, but not a single document has been delivered. The court has ordered the SEC to search all the relevant repositories for the documents and discovery, for communications between the SEC and external third parties relating to XRP, Bitcoin, or Ether. After the SEC resisted, the court reaffirmed that the SEC must produce communications with third parties, including external agencies and market participants. Despite that repeated instruction, the SEC persists in refusing to search an obvious repository to responsive evidence on external communications, the defendant said. Ripple's motion asks the court to order the SEC to search for and produce documents about Bitcoin, Ether, and XRP from the SEC's FinHub electronic mailbox and produce the SEC Trading's policy related to digital assets and virtual currencies no later than June 18, 2021. Given the SEC's most recent request to the court to extend the deadlines for both fact and expert discovery by 60 days, it seems that the SEC is looking to stall the case, Ripple argued. The SEC has repeatedly delayed its production, while telling the Judge Torres that the ordered discovery was irrelevant and needless, and asking the court to extend the discovery deadlines based inter alia on the fact that defendants have raised a number of concerns regarding the SEC's review and production of internal documents and communication responsive to Judge Netburn's April 6, 2021 order. In other words, the SEC cites its own delay as a reason for extending the schedule. The only way to solve this problem is with strict deadline, the motion stated. In its request to extend the deadlines, the SEC admits the defendants do not consent to the SEC request because they contend that the SEC had sufficient time to investigate this matter before filing suit and because Ripple want to move to summary judgment as soon as possible. In addition to this SEC request, both parties have filed a joint motion to extend the time until June 9, 2021 to meet and confer regarding documents redactions and sealing of certain exhibits, hoping to avoid burdening the court with unnecessary disputes. A few days ago, the court denied the SEC's motion to compel Ripple to produce memos discussing XRP sales with the firm lawyers, a motion that Ripple Labs argued went against the rule of attorney-client privilege. This was an important win for Ripple. Attorney Jeremy Hogan was most recently published a video explaining how a settlement between the SEC and Ripple would like, the chronology of the whole saga. Earlier this year, the defense case of the San Francisco firm had looked dead in the water, but the tide may now be turning in Ripple's favor, according to legal observers. The SEC filed its lawsuit in a few days before Christmas 2020, claiming its founders had illegally marketed its native XRP token to retail customers, allowing the firm to raise business capital through its sales as an unregistered securities offering. SEC prosecutors stated a failure to register sales was in violation of federal laws. They also claimed Ripple chairman Christian Larson and CEO Brett Garlinghouse orchestrated personal unregistered sales to the value of $600 million. At the time, Garlinghouse branded the case as an assault on crypto at large, saying the SEC is fundamentally wrong as a matter of law and fact, before reaffirming earlier statements that the founders would consider uprooting from their California HQ and move the operation to another country. Now, 6 months on, and after a series of bruising battles, it appears the odds are now with Ripple. 2 days ago, the latest ruling in the case saw Judge Sarah Netburn slap the SEC down after it demanded to see evidence of Ripple's legal advice over the securities status of XRP going back to its launch in 2013. However, Judge Netburn denied the SEC, saying Ripple asserts that the SEC's requested communications are protected by the attorney-client privilege, which has not been waived. The move in Ripple's favor now adds weight to its defense of fair notice, which argues that prosecuting authorities failed to provide any warnings against the firm's action prior to lawsuit being filed. This, say legal commentator Clive Brabin, could easily be the turning point of entire case, which he believes has now swung in Garlinghouse and Larson's favor. Judge Netburn's ruling here could well be the key moment throughout this whole action. He explained, the SEC has now hit a brick wall in its pursuit of access to documents that Ripple's lawyer maintained are confidential, something which is now supported by law. It is a very important point and one which now places great deal of emphasis on the fair notice defense, which could yet make or break this whole case. Possible outcome of the case. Positive. Ripple is currently one of the major coins with a huge volume of trading and large community. In addition, they say that the Ripple is the coin of a bank with large capital invested by bankers. That said, even if sanctions are imposed, they will be resolved successfully by bankers. Another point is that Ripple won a case against the blockchain consortium R3 this year, which includes more than 70 retails and investment banks, including Barclays, HSBC, and UBS. This demonstrates that the organization's legal support increasing its chances of winning the case. Negative. Among the worst consequences that can be seen are the listing from all US crypto exchanges, fines, expensive lawyers, endless lawsuits, an uncertain future, and a massive sell-off of XRP. The implication can be very serious. Furthermore, the SEC had cases when companies and individuals were criminally responsible, which led to the company's closure, as with the Arise crypto bank. Neutral. Even if, in some SEC instances, the business was not closed, it had to rebuild its business model. When the company wanted to issue a Gram token and tried to get under an exception with securities legislation, this was the case with Telegram. But although the money taken from investors was requested to be returned, this did not lead to her closure or serious criminal liability. That's all for today. If you have any question regarding crypto, do not hesitate to reach out to us in the comment section. To continue enjoying more of our crypto videos, kindly subscribe to our channel. Do us a favor by liking, commenting, and sharing our content with friends or across social media channels.